Assalamualaikum warahmatullahi wabarakatuh. My name is Muhaizah binti Muhammad Kifli, metric number 046350. So for the introduction, international humanitarian law can be defined as a set of rules that seek to limit the effect of armed conflict on people, including civilian, on humanitarian ground. International humanitarian law protect people who do not or no longer engage in hostilities. In order to achieve its objective, international humanitarian law covers two areas, which are the protection of peoples and also restrict the means and method of war. International humanitarian law must be enforced fairly by all parties to any armed conflict, regardless of whatever their cause is justified. The equality between warring parties also make a critical distinction between the armed conflict to which international humanitarian law applies. International humanitarian law finds its sources in treaties and in customary international law. The rules of international humanitarian law are set out in a series of conventions and protocols.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Salma binti Mamadi and my metric number 047316. First of all, who is the guardian of international humanitarian law or IHL? The answer is ICRC or International Committee of the Red Cross. The ICRC has a recognized role in the interpretation of the international humanitarian law, and it is charged to working towards its faithful application in armed conflicts. IHL distinguishes two types of armed conflicts, which are international armed conflict or IAC and non-international armed conflict NIAC between governmental forces and non-governmental armed groups, or between such groups only. Two main legal sources must be examined in order to determine what a non-international armed conflict under international humanitarian law is. A. Common Article 3 to the Geneva Convention of 1949 and B. Article 1 of Additional Protocol 2. So that's all.
My name is Aidil Azizah bin Zulkifli and my metric number is 047149. So, we talk about the non-intentional armed conflict. When we said about the non-intentional armed conflict, it always related to the Article 3 of Geneva Convention. In this Geneva Convention, Article 3, there is no minimum provision of the international humanitarian law shall apply. This convention do not define the meaning of the non-international armed conflict, but it now start to accept, but in terms of the dispute between the non-state and armed group. Under the command of the Article 3 of the Geneva Convention, it states that the armed conflict could potentially exist between two groups without any involvement of the state. Next, we go to the second rule of the applicable of the Additional Protocol 2 of 1977. Meanwhile, of the Protocol 2, it defined the armed conflict which take place in the territory of the high contracting party between its armed force and rebellious armed force on the other organized armed group, which this dispute will involve only between them, group and group, without involvement of the state. So, it should be noted that the regulation in the Protocol 2 concern non-international armed conflict are now that those under Common Article 3. As result, Protocol 2 introduced a requirement of territorial control for non-state actors. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nushakira binti Haris. My metric number is 047487. So moving on to the applicability of the IHL. The second rule applicable is Additional Protocol 2 of 1977. Meanwhile, for the protocol, it defines the armed forces which take place in the territory of high contracting party between its armed forces and rebellious armed forces or other organized armed groups, which, under responsible command, exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol based on Article 1. It should be noted that the regulations in Protocol 2 concerning non-international armed conflicts are narrower than those under Common Article 3. For instance, Protocol 2 introduced a requirement of territorial control for non-state actors, while Protocol 2 applies only to armed conflicts between states, armed forces, and rebellious armed conflicts or other organized armed groups. Common Article 3 applies also to armed conflicts occurring only between non-state armed groups. In this context, it must be reminded that Additional Protocol 2 develops and supplements Common Article 3 without modifying its existing conditions of application. This means that this restrictive definition is relevant for the application of Protocol 2 only, but does not extend to the law of non-international armed conflicts in general. That's all from me. Thank you.
Assalamualaikum. My name is Nurbella Ayu binti Muhammad Shukri, metric number 046372. Okay, IHL itself consists of limitation in addressing the conflict among the non-international armed conflict. Among of the limitation is that in IHL, counterterrorism is allowed, but with exception, which it cannot deprive the human rights of the citizen, while the legal framework governing terrorism and IHL may have some common ground. IHL expressly prohibited most acts that are criminalized as terrorist. However, in legal term, armed conflict is a situation in which certain acts of violence are considered lawful and others are unlawful, while any act of violence that are designated as terrorist is always unlawful. So under this reason, the parties to a conflict, they are permitted or at least not prohibited from attacking each other military objective, or individuals are not entitled to protection against direct attack.
Assalamualaikum and hi. My name is Faris Hakimi bin Yahya with metric number 047236. So, the unequal balance of military power often results in such opposition groups going underground and adopting styles of warfare contrary to IHL. Examples include locating themselves in the midst of civilian populations, thereby exposing civilians to increased risk and potentially using them as a human shield, which is prohibited by IHL, and engaging in unlawful. In addition, incorrect designation of acts that are lawful under IHL as terrorists further the insensitive non-state armed groups to comply with IHL with an amnesty to bring a non-international armed conflict to an end. This and other challenges have put fundamental principles of IHL under strain, such as the concepts of non-reciprocity and the equality of belligerents. IHL is not concerned with the legitimacy of any cause pursued by belligerents. Rather, it's ordered to ensure that all parties to an armed conflict possess the same right and obligation in order to ensure equal protection to protected persons and objects impacted by any conflict, which is not provided for within legal frameworks against terrorism. Significantly too, IHL does not confer legitimacy upon non-state armed groups which are a party to a non-international armed conflict, where the principle of non-reciprocity is not respected. It reduces the willingness of both state armed forces and non-state armed groups to fully comply with international humanitarian law, thereby further endangering the civilian population.
So to conclude, as proposed by the ICRC, there are two types of armed conflict, which are the international armed conflict and non-international armed conflict. The international armed conflict exists whenever there is result of armed forces between two or more states. Meanwhile, the non-international armed conflict, protected armed confrontation occurring between governmental armed forces and the forces of one or more groups. The armed confrontation must reach a minimum level of intensity, and the parties involved in the conflict must show a minimum of organization. There is no such thing as a war against terrorism. With the respect of the various armed conflict and the numerous counterterrorism measures at the domestic and international levels, the ICRC adopts a case-by-case approach in order to analyze and legally classify the various situations of violence. So that's all from our group. Thank you.